Hello, everybody. Well, hello, Ava. Little Miss won't go outside since people are still lighting off fireworks. Yeah, hi. Come here, Ava. Come on. There you go. There you go. Well, I get to spend my day getting eaten up by vampirous pterodactyls. Yeah, I had to attempt to mow the lawn, sort of, in my way. The best I could, it's hard to do it when, everything from your tailbone down is numb, but I make do. I'm not even numb. I mean, numb would insinuate there's no pain. Asleep. Dead asleep. Yeah. Hello, Nana Laura. Thank you for letting me know that I have absolutely no idea what I'm doing. She texted me because I accidentally had it set for tomorrow at this time. So StreamYard was saying that it was 24 hours, and it wasn't. It really wasn't. Oh, I was fresh out the shower when I saw your message, and yeah, I fixed it right away. Thank goodness my phone is also my alarm clock, so it goes with me everywhere. Testes. 1, 2, 3. Hey, that'd be amazing. Thank you, Mortimer Duke, my love. Hello, Eileen Carlin. Hello, Buzzy Pug. Yeah. We are already back to the future. Hello, Charlie. Hello, Army Brat 1964 and Smokey. Just to help me out. Just to keep me in check, in line. Unfortunately, there's no consequences other than to me. What am I gonna do? Revoke your viewership? Oh man. Am I gonna make this job hard for you? Oh, not eternal. I mean, just while you're here. No. Oh my gosh. Oh, what a great crew I have. You guys are absolutely the best. All right. Oh my gosh, it's so warm in here. Oh, we're in the humidity season. Like there is no summer. It's just humidity. All right, guys. Let's check this out. We got one the PAWFURM gets to weigh in on. It's a little bit into it, but yeah. The kiddies are saying that this guy needs to be let off. Prosecutors need to dismiss the charges altogether. He's not guilty. In fact, he's not even not guilty. He's just flat out innocent if you ask the kiddies. So
Victor Hernandez, can you hear me okay?
Yeah.
Miss Graver, are you there? There you are.
Yes, I am.
File 251091 SD, People versus Victor Hugo Hernandez, here today for sentencing. And the court file shows this was a charge of operating while intoxicated, pled guilty to that charge on May 30th of this year. At that time, I ordered a substance abuse assessment, had a criminal history run. Both of those have been completed, so we are able to proceed to sentencing today. Mr. Hernandez, are you with us?
I am, Your Honor.
Are you able to appear on a video?
For some reason, my phone wasn't allowing me to get that video connection to go through. I had that same problem last time. So I think the phone's going to be the best bet right now. I don't have a laptop to use.
It sounds like it is the best we're going to be able to do. So in any event, substance abuse assessment has been completed, so we are able to proceed to sentencing this morning. Court file shows this was resolved at the time of a pretrial conference with the prosecutor's office. In writing at that time, the prosecutor waived their presence at your sentencing. So Mr. Hernandez, this is your chance to tell me anything you would like to for your sentencing today.
Okay, Your Honor, thank you for this opportunity. I understand, that all of this is the consequences to my actions. With that being said, I am, thankful that I am in the situation. Things could have went worse, and I am aware of that. I could have harmed not only myself, but somebody else, and I'm glad that, this is almost like the best worst case that could have happened. At the time, I had just lost a friend 2 weeks prior to that because of drinking. Just lost my job. And then my mother had also lost her job because of immigration statuses and stuff. So with that being said, I am the head of household right now, taking care of everything. Started up my business again, detailing business to try to make ends meet, just to make sure that not only my mother's everything is covered, but myself. And I have been seeking out counseling and going to AA meetings when I do get the urge to drink. I've met great people there that have been helping me with this journey. And whatever happens and whatever you do decide, I understand that, like I said, those are the consequences to my actions, and I had to own up to them. So thank you for the opportunity to speak to you and speak my mind.
Ms. Graver, on behalf of your client for sentencing.
I have nothing additional, Your Honor.
Mr. Hernandez was arrested before for the same thing back in 2016. It looks like, not sure what happened or why, but those charges were dismissed. So he avoided a drunk driving in 2016. Not so lucky this time. It looks like he lives up in Grand Rapids. And back in April at about 11 o'clock at night, they clocked you southbound on 131 away from Grand Rapids doing 83 miles an hour and found that you were over 1.5 times the legal limit at a 0.147. So I don't know where you were going, but you were going away from your home, and blood alcohol was not as high as a lot that we see. However, concerning, particularly since you already went through this once before with a arrest and court case that actually got resolved, that would have been probably enough to scare off most people from drinking and driving again. However, didn't work that way for you.
And not only that, but he said he had just recently lost a friend to drinking. So you honor your friend's life and passing by getting drunk and driving a vehicle?
Some reason. So where were you headed to southbound on 131?
Your Honor, I was on my way to see a friend. Like I said, I had just went through the loss of good friend of mine, and at the time I was not doing good mentally or at all. This person did not know I was drinking, so once they found out I had went to jail and everything, they told me if I would have told them I was drinking, that they would have came to see me instead of the other way around. Yeah, I just wasn't doing good mentally at the time, and I had certain thoughts that I just didn't sit right with me, and I had to reach out to somebody, and yeah, that's where I was going.
Well, if you hadn't been doing 83 miles an hour on the freeway, you might have made it there. The issue is your personal problems turn into public safety problems when you're out there on the freeway with that kind of a blood alcohol heading away from your house, which means, again, you got a long way back home on the trip back as well. So my concern is, again, this is a second arrest for you for a drinking and driving offense. Your blood alcohol was getting close to twice the legal limit. And I'd like to make sure this is not going to be a situation where you're pulled over a third time for the same thing. So on this charge, I do believe our probation department can provide some appropriate services. Given that, we'll place you on probation for a period of 6 months, and that will be with substance abuse counseling as directed by the probation department. Standard condition of probation is you not possess or consume any alcohol, marijuana, or illegal controlled substances. They will have the authority to check you for that here at the probation department, have you checked by the police at your home, or have you physically monitored for alcohol consumption at any point while on probation. On this charge, they'll also have you complete a victim impact panel. On an operating while intoxicated charge, has your license already been suspended?
Yes, Your Honor.
Okay, specific condition of your probation will be that you not drive without a valid operator's license. So getting caught driving for any reason would be a violation of your probation, could result in a probation violation, a jail sentence. So no driving until your license is restored by the Secretary of State's office. The charge of operating while intoxicated, the fine is $500. Court costs are $400. State costs and fees are $125. There is a $180 fee for that term of probation and a $100 fee for the substance abuse assessment done through the court for a total of $1,305. Court file shows you released from our jail on a $500 PR bond. So all of that is due, but you will have the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. As to your probationary sentence, Mr. Hernandez, required to inform you that you are eligible to be discharged at the halfway point if all the terms and conditions of your probationary sentence have been completed at that time. So in your case, Mr. Hernandez, you can have this all wrapped up in as soon as 3 months. Our probation department is going to contact you on the telephone and set up your probation order so you won't have to drive down here to Allegan County. What telephone number can they reach you at today?
The current phone number I'm using, so that will be 616, Your Honor.
Okay, with that, you are free to hang up from the court proceeding. Be available at the telephone number you just gave us. Be receiving a telephone call at that number from our probation department shortly. Good luck to you, sir. I hope we can get this all wrapped up in the first 3 months. Thank you, Ms. Graber.
I don't hope he can get it wrapped up in 3 months. I don't hope he can get it wrapped up in 6 months. I think that was way too light of a sentence. And I'm from Wisconsin, guys. Many of you know I lost a very close childhood friend to a drunk driver. So I have no time tolerance or respect for the practice. And I think that these lenient sentences for people who are caught drinking and driving are absolutely ludicrous, and shame on the courts. They have the opportunity to monitor these people for longer. I'm not saying hit them with harsher fines. I mean, that doesn't work. But as Charlie suggested, an initial interlock device, scram tethering, You know, we have tools, we have resources. 3 months probation, that's a slap in the face to drunk driving victims and their families.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah. Patricia Hudson, can you hear us?
I'm trying to, 1 second, please. I'm trying to park my vehicle. I'm here.
All set? Okay.
This is file 244493 SD, People versus Patricia Irene Hudson, originally charged in a misdemeanor complaint issued by the Allegheny County Prosecutor's Office on a charge of operating while intoxicated. At the time of a final settlement conference for a jury trial, the prosecutor's office reduced this to a charge of operating while impaired. At that time, I ordered a substance abuse assessment, which has been completed, so we are able to proceed to sentencing this morning. The settlement conference form also indicated that the prosecutor was waiving their presence at sentencing. So with that, Ms. Hudson, this is your chance to tell me anything you would like to for your sentencing this morning.
Yes, Your Honor. I didn't write anything down, so I do apologize. But I would like to say, first off, I want to thank my lawyer, Ms. Taylor. She's been standing with me for a year now. This case has been going on for a year. I also would like to apologize about my actions in regards to the case. It's been a long year, Your Honor. It's been a long, trying year for me. And I'm not trying to make an excuse because of my actions. I'm not trying to excuse my actions. But it has been a trying year. Miss Taylor knows that. I just wanted to be over with. So with that being said, I understand what I did wrong, even though I was trying to do good, and Miss Taylor knows that. But a good action turned into a negative consequence for me. And I understand every action, whether good or bad, comes with a pro and a con. And this is a con to a positive action that I did. I'm not going to ask for a lightened sentence, but I am asking you to be thoughtful when it comes to sentencing, because like I stated, this has been one trying year for me. So that's it, Your Honor. Thank you so much for letting me speak.
Okay. Ms. Graver, on behalf of Ms. Hudson for sentencing.
Thank you, Your Honor. As a little bit of background for this case, when Miss Hudson had interacted with the police, she had pulled over and was awaiting a ride because she did start driving and then realized that she was not in a safe position to drive, and pulled over and eventually did have police contact, and that is how this happened. She ended up making the right call to not drive, but unfortunately it came a little too late, and that decision should have been made before she got behind the wheel. And she does take full responsibility for that. And as she indicated, this case has been going on for a year. She's been doing a lot of reflecting. She has no interest or desire in drinking. She indicated to me she is not a drinker in general. And this was one night that she went out with friends. And unfortunately, it led to these consequences. And we ask that the court take that into consideration. Thank you.
Reviewing materials yesterday for today's sentencing, it looks like Ms. Hudson has no prior drinking and driving offenses, which is good. Blood alcohol in this case was twice the legal limit at a 0.16. So because of that blood alcohol content, I do think that probation can provide some appropriate services for Ms. Hudson, and will place her on a short term of probation for a period of 6 months. Specific conditions of probation are, first of all, that you not possess or consume any alcohol, marijuana, or any illegal controlled substances other than substances prescribed to you by a medical professional. They will have the authority to check you for that here at the probation department, have you checked by the police at your home, or have you physically monitored for alcohol consumption at any point while on probation. on this charge will also require completion of a victim impact panel. On the reduced charge of operating while impaired, the fine is $300. Court costs are $400. State costs and fees are $125. There is a $180 oversight fee for that term of probation and a $100 fee for the substance abuse assessment that was done through the court, for a total of $1,105. Court file shows you were released from the Allegheny County Jail on a PR bond, so all of that is due. You will have the entire time on probation to pay that amount on a monthly payment plan set up through the probation department. As to your probationary sentence, you are eligible to be discharged at the halfway point if all the terms and conditions of your probationary sentence have been completed at that time. So in your case, you could have this all wrapped up in as soon as 3 months. Probation department's going to contact you on the phone in a few minutes to set up that probation order with you. What telephone number can they reach you at today?
251.
With that, you're free to hang up from the court proceeding. Be available at the telephone number you just gave us. Be receiving a telephone call at that number shortly from our probation department. Good luck to you, Ms. Hudson. Thank you, Ms. Graber.
Thank you, Your Honor.
The only thing that I can give her versus the last guy is at least she pulled over when she realized she was too intoxicated to drive. He drove faster. But bottom line is she should have never gotten in the car in the first place. Yes, she absolutely was. And she should be. She should be, but I think she's crying for the wrong reasons. She's crying because she's being sentenced. She played victim the whole time through taking full responsibility. That's not taking responsibility. That's playing victim and saying, you know, yeah, I'm guilty of it, but I had good reason. No, you didn't. No.
Your Honor, we do have bar and low ball in the room. Okay. Jennifer Lovo. On the record in state of Michigan versus Jennifer Lee Lovell, 2002810FY.
Assistant Public Defender Jennifer Guardian, Ms. Lovell.
Okay. And are you Jennifer Lovell on the video?
Yes.
Okay. Ms. Lovell, I'm just trying to figure out the file. It's been around a while. I guess we'll start with, there's a bench warrant in here that says you failed to report to jail on August 27, 2021. That is the reason that you had a warrant out for you. But to give you sort of a recap, back in 2020, you pled guilty to, looks like an amended count 1, improper possession of a weapon in a vehicle. Looks like that was punishable by up to 90 days in jail. December of 2020, you received a sentence. And in 2021, you pled guilty to some probation violations. Probation was terminated. You were ordered to serve 21 days over the course of weekends beginning August 21st of 2027. Looks like you did not show up to serve your first, August, you were supposed to start out serve sentence, 7 weekends starting August 27, 2021. If I said that backwards, I'm sorry. And a warrant was issued because you did not show up to serve your weekend in jail. Mr. Hardy, anything to, I guess, give to the court regarding this warrant?
Not at this time, Your Honor. I would leave this to the court's discretion.
Ms. Lovell, do you have any other legal matters pending at this time?
No.
No. All right, Ms. Lovell, you owe the court 21 days jail. You are remanded to serve your 21-day sentence. And then after that, I think that should resolve this file. Let me just make sure. There's one other thing to check.
No.
Yep, you just have to serve your sentence and you'll be done. Since I gave you your jail sentence, although it is the sentence that Judge Alderson sentenced you to back in 2021, you have the right to appeal my sentence. If you would like to appeal and you need a public defender to assist you with that appeal, you need to make your application within 14 days. Any questions?
So I don't have to serve the time right now?
No, you do, right now. You're gonna serve your sentence right now,
Okay.
and then you'll be done. Okay. All right. Mr. Hardy, anything else for Ms. Lovell?
No, Your Honor.
All right, thank you. Nicole Farr.
Your Honor.
Just trying to read your file here. Okay, on the record in state of Michigan versus Nicole Farr, 2200953FY. And you are Nicole Farr?
Yes, ma'am.
Okay. Ms.
Assistant Public
Farr,
Defender.
looks like, yeah, Mr. Hardy, I didn't know if you could be appearing in this because it's a collections file.
Oh, okay.
Ms. Farr was arrested for something else last night, but apparently they have not authorized charges for that yet, so it's just collections.
Okay.
Okay, Ms. Farr, this is an old file apparently for which you have a balance due. According to the clerk, gosh, this is old, so I'm not 100% sure. I have to look it up. Last I knew, it said that you owed $562.08. I think that might be right, but let me make sure. Oh, okay. There's a bunch of files here. I have to add them all together, I guess, because
Bill is
actually
207.
there's 562.08 in this file, and then you have like 1, 2, 3 expired meter tickets at 108 a piece. And then, 108 times 3. Then you have 2 handicap parking tickets at 186 a piece. So if we really add that up, it's $1,258.08. That's everything. It looks like you were supposed to set a payment plan in March of 2025. You didn't, I guess, follow through on that. There was, they scheduled you for a show cause hearing April 22nd, 2025. Looks like you might not have shown up for that. They set you for an arraignment June 23rd of 2025, again, didn't show up. So I guess, Ms. Farr, I guess I need to verify firstly that we're sending things to the right address. What is the correct address for you? Okay, so we're using the right address. Why aren't you taking care of addressing the court on this?
I've been in the hospital, ma'am. 15. This is going on my 15th time. My son is in need. He needs a blood transfusion. Yes, ma'am. His dad is using and abusing his federal money, and I owe 207. And I ran my Social Security paperwork.
You don't. You owe $1,258.08, and you need to come in here and set up a payment plan on this.
I'm Erin Dwayne Carlisle's mother. Yes, ma'am.
I don't know what that means.
I want an Amber Alert on Damian Cortez Carlisle Sr. He is using and abusing my son, and Aaron is rotting from the inside out. He has bed bugs, parasites all over his body.
Ms. Farr, you can make a police report on that. Right now, all I'm talking to you about is you setting up a payment plan.
I've been here privately, ma'am. I have my paperwork on my right side. Yes.
So all I want to talk to you about is setting up payment arrangements on all this money you owe.
His dad is abusing it, ma'am. I'm gonna have medical records.
You make a police report on that, but I can't address that for you. I'm sorry. Ms. Farr doesn't seem competent to have this conversation today. Ms.
Okay,
Farr,
I'm listening. Right
no,
now,
we're trying to talk about payments and you seem to not be able to connect with me about payments. Ms. Farr, are we gonna set up a payment arrangement or do something about all this money you owe that you haven't been coming into the court to talk about?
I would like to set out an Amber Alert. I'm here
Okay, that's
privately.
not related.
I'm here privately for myself and my son.
Are you a CMH consumer?
Yes, I've had 14 hospital visits, ma'am. I have medication.
Are you under a current treatment order?
Nope, I take my medications as prescribed.
Yeah, I'm just wondering if you need some assistance with that, because at the moment, you seem to be a little bit disconnected from what we're trying to do here. When's the last time you went and saw your treatment provider?
That was 6 months ago.
Okay, did you miss an appointment?
Oh, I turned myself in on a personal recognizance bond, 5/23/25. I got accepted into LCC college.
Uh-huh. Okay, I'm going to pass this matter and see if CMH wants to come talk to you, because it seems like you're unable to have a conversation about this.
I'm my own representative, ma'am. I'm here privately.
Yep,
Picked up.
okay. To the jail, if I get information back from CMH, we can maybe see her later, or she'll have to see the magistrate tomorrow, but I'm trying to get info from CMH for her. Okay. Thank you so much. Thank you.
Oh, you with us? You turn your video on?
I'm sorry?
Can you turn your video on?
Oh, yes, sir. 1 second while I cut on the lights. I'm sorry.
Okay.
Sorry. Good morning.
On the record, on file 251619 SD. People versus Anith Chol here today for a pretrial conference on a citation issued by the Allegheny County Sheriff's Department on a charge of operating while intoxicated, second offense. Also a charge of driving while your license was suspended. Have received a pretrial conference sheet which indicates the prosecutor's office will reduce the first charge to a charge of operating while intoxicated, first offense, and that you'll also be entering a plea of guilty to a charge of driving while your license was suspended. Ms. Cho, is that what you've agreed to do?
Yes.
The charges you're pleading guilty to are as follows. First, a charge of operating while intoxicated, first offense. Operating while intoxicated, first offense is a misdemeanor charge. It carries a maximum penalty of 93 days in jail and a $500 fine. In addition to that, the Secretary of State's office will then assess 6 points against your driving record. In addition to that, your driving history shows that you have a prior conviction from less than 3 years ago up in the city of Grand Rapids for a charge of operating while intoxicated while having a high blood alcohol content. If you plead guilty to this charge, the Secretary of State's office will then totally revoke all your driving privileges for at least the next year. Driving while license suspended is also a misdemeanor charge. That charge carries a maximum penalty of 93 days in jail and a $500 fine. In addition to that, the Secretary of State's office would assess 2 points against your driving record, and they would also suspend your driver's license for an additional period of time. Were you aware of all of that?
Yes.
And knowing all of that, do you still wish to plead guilty to both those charges?
Yes, sir.
If you do plead guilty to those charges, you will not have a trial of any kind, and you'll be giving up all the following rights. First, the right to have a trial by a jury or a trial by a judge without a jury, and that will be at your choosing. You have been appointed an attorney in this case at public expense. She would be there representing you if you had a trial in this case as well. At a trial, if you had one, you would have the right to call witnesses to speak for you on your behalf. If you needed help to get those witnesses to court, I would order them to appear on your behalf. At a trial, if you had one, you would have the right to see, hear, and question all the witnesses that were called against you. You'd also have the right at a trial to testify yourself or to not testify and remain silent. If you chose not to testify at your trial, the prosecutor cannot comment on that fact before the jury. Finally, if you had a trial in this case, you'd have the right to be presumed innocent until the prosecutor proved beyond a reasonable doubt that you were guilty of these charges. And do you understand those rights that I've read to you?
Yes.
Those are your trial rights. If you plead guilty, you will not have a trial and you will give up all those trial rights. Do you understand that?
Yes.
Has anyone promised you anything regarding what your sentence will be if you do plead guilty today?
No.
I have not agreed on what your sentence will be. Knowing that, do you still wish to plead guilty?
Yes.
Are you currently on probation or parole to any court?
Yes.
And which court are you on probation or parole to?
Kent County for that prior charge there.
If you plead guilty to a new charge while on probation, that is an automatic statutory violation of your probation, and you could be jailed on a probation violation up in Kent County, in addition to whatever I do here in Allegan County. Were you aware of that?
Yes.
And knowing that, do you still wish to plead guilty?
Yes, sir.
Anyone threaten you to force you to plead guilty?
No, sir.
Is it your choice to do this?
Yes.
And finally, are you pleading guilty to this charge because you believe you're guilty of this charge?
Yes.
Case was initiated through a citation written by the Allegheny County Sheriff's Department. It states on May 8th of this year at approximately 2:45 in the morning, you operated a motor vehicle on M89 in Gun Plain Township here in Allegan County. Were you operating a motor vehicle on that date and at that location?
Yes.
And before driving, were you drinking alcohol?
Yes.
Did you take a breath test or a blood test in this case?
I took a breath test.
What was the result of your breath test?
0.17, I believe.
0.17, okay. On that date, was your driver's license suspended?
Yes, sir.
Based on that, I will find a factual basis as to the reduced charge of operating while intoxicated first offense, also to the charge of driving while your license was suspended. On the first charge, required to have you go through a substance abuse assessment prior to sentencing. Our probation department will do that for us. And they will also set this for a date and time for sentencing at a later date. Do you have any court proceedings coming up in Kent County?
Just my PO appointments on
Did you
July
tell your
7th.
Did you tell your PO you were arrested for the same thing in Allegheny County?
Almost immediately after, sir.
And they have not filed a violation yet?
The last time I saw her, she wanted to know what was said after this court date.
After this court date, okay. Probation department's going to contact you on the telephone to get that substance abuse assessment going. What telephone number can they reach you at today?
616.
Okay, you are free to hang up from the court proceeding, but be available at that telephone number. They will contact you at that number to start the process for the substance abuse assessment. They will also set a date and time for your sentencing. Your sentencing will be in a couple weeks on a Thursday morning at 8:30. We can take care of it just like this over the video. But at this point, go ahead and hang up from the court proceeding. Be expecting a call from our probation department. Okay?
Thank you.
Thank you. Thank you, Ms. Graber.
Thank you, Your Honor.
Philip Green, can you hear me okay?
Yes.
All right, guys. This is the case. This is the case the cats have been raving about. Ranting and raving. Telling you, they want him freed.
Right video.
This is file 251396 SM, People versus Philip Michael Green. Here this morning for pretrial conference on a misdemeanor complaint issued by the Allegheny County Prosecutor's Office on a charge of retail fraud in the 3rd degree. I have received a pretrial conference sheet, which just indicates you've now decided to plead guilty to this charge. Is that what you agreed to do?
Yes, Your Honor. Yes, Your Honor.
This charge is a misdemeanor charge. It carries a maximum penalty of 93 days in jail and a $500 fine. Knowing that, do you still wish to plead guilty to this charge?
Yes, Your Honor.
If you do plead guilty to that charge, you will not have a trial of any kind, and you'll be giving up all the following rights. First, the right to have a trial by a jury or a trial by a judge without a jury, and that will be at your choosing. You have been appointed an attorney in this case at public expense. She would also be there representing you if you had a trial in this case as well. At a trial, if you had one, you would have the right to call witnesses to speak for you. If you needed help to get those witnesses to court, I would order them to appear on your behalf. At a trial, if you had one, you would have the right to see, hear, and question all the witnesses that were called against you. You'd also have the right at a trial to testify yourself, or to not testify and remain silent. If you chose not to testify at your trial, the prosecutor could not comment on that fact before the jury. Finally, if you had a trial in this case, you'd have the right to be presumed innocent until the prosecutor proved beyond a reasonable doubt that you were guilty of this charge. And Mr. Green, do you understand all those rights that I've read to you?
I do, Your Honor.
Those are your trial rights. But if you plead guilty, you will not have a trial and you will give up all those trial rights. Do you understand that?
Yes, Your Honor.
Has anyone promised you anything regarding what your sentence will be if you do plead guilty today?
No, Your Honor.
Anyone threaten you to force you to do this?
No, Your Honor.
Is it your choice to plead guilty?
Yes, Your Honor.
And finally, are you pleading guilty to this charge because you believe you're guilty of this charge?
Yes, Your Honor.
Were you at the Family Dollar store in Martin Township on April 12th of this year?
Yeah, yes, Your Honor.
And did you steal or attempt to steal property that Family Dollar was offering for sale?
Yes, Your Honor.
And what was that?
It was catnip, Your Honor.
And did they get that back or did you leave the store with it?
I left the store with it.
Okay. Based on that, I will find a factual basis. We'll find that your plea is knowing and voluntary. Your plea will be accepted to the charge of retail fraud in the 3rd degree. Mr. Zacharzecki, any restitution request? We have none on the court file. Or let us know if you want us to set it for sentencing.
I'm pulling it up right now. Restitution form. So it looks like the form was sent back in April 25 of 2025. I do not see that there has been any response at this point.
Okay. With that, Mr. Green, this is your chance to tell me anything you'd like to for your sentencing today.
Okay, Your Honor. Well, I remember having a rough day at work. I have a pretty severe case of OCD and ADHD, and I went into the store because I had forgot the catnip at the last place I was at, and I asked the cashier if they had any catnip, because I went back there and I couldn't find it. So as she showed me the catnip, I realized I didn't have my wallet on me, and I was kind of looking for it. I must have put it. I did put it in my pocket, I guess, but I didn't realize it until I got home. Until the next day when the officers knocked on the door. Like, I think it was 8 o'clock in the morning, and they asked me if I had it, and I looked in my pocket, and sure enough, it was in my pocket. And I said, well, I would like to go pay for this, And he said, well, at this point, you're being trespassed from the Family Dollar. So I said, okay, well, I'll give him a call. So I called the manager at Family Dollar, and I told her that I was sorry, that, I didn't mean to steal it. And I explained my situation to her. And I says, I would like to offer to pay for it. And she said, well, you can't come in to pay for it because you've been trespassed. I says, okay, I will leave. The catnip was $2.95. I left a $10 bill. I told her I would leave a $10 bill in the mailbox. And she says, okay, just don't come back in. And at that point, I figured that everything was taken care of, but apparently it wasn't. Like I said, I apologized and I paid for it. So here we are.
Okay. Well, Mr. Green, you just indicated this was not intentional. You didn't intend to steal. You put it in your pocket, forgot about it, and left the store without thinking about it. Given that I'm not going to accept your plea, we're going to leave this on for a settlement conference and a jury trial. And Ms. Graber will explain why when she talks to you in a moment. Okay?
Okay.
You're all set today. Thank you.
Okay. Thank you.
Ms. Graber, would you like a breakout room with him, or are you just going to call him?
Can I get a breakout room, please?
Good morning. Is it Levine or Levine?
Levine, sir. Thank you.
Good morning, Mr. Levine. I'm Judge McBurney, and I need to mute that. There we go. You and I are talking today. I'm here in court. You're going to tell me where you are in a minute. It's fine that you're appearing virtual. I'm just curious where you are. You are challenging the denial of unemployment benefits in your case. And I'm going to hear from you the reasons why you think I ought to reverse the Board of Review that considered the administrative law judge's ruling that you were not entitled to those unemployment benefits. I've had the benefit, to reuse that word, of looking at the record below. There's a transcript of the telephonic hearing you had with the administrative law judge, where there was a representative from the employer there and you were there. So I've seen that ruling, and I just need to impress upon you before I hand this over to you and hear everything and anything you want to share with me, that the scope of my review in appeals like these is limited in two ways. One, I cannot find any new facts. So you may share with me some things that aren't necessarily in the record that was made below, and that's fine, and I'll hear about them, but I cannot rely on that evidence. I'm restricted to the evidence that you presented and the employer presented during that hearing below. So primarily my review is for errors of law, although I could conclude that the evidence presented below simply wasn't sufficient to support the ruling of the administrative law judge. But for the most part, judges in my position are restricted to looking at, well, sure, there was evidence that you were fired for cause, but that evidence was hearsay, or it shouldn't have come in, or there was a procedural defect such that either you're entitled to a new hearing, or every once in a while, they just got it wrong. And I reverse it and say, give the man his benefits. But I do want to manage your expectations that if you were here with, like, you know what, Judge, I've got the smoking gun, here it is. I got this certificate, best employee ever. How could, like, what are they saying? I did a bad job. If that's not what you shared with the judge below, I will admire the certificate for best employee ever, but it wouldn't be something that I could point to say, here's why Mr. Levine we shouldn't have characterized this as termination for cause, because that's not something you shared with the judge who heard it before. Okay?
Understood.
End of my spiel, and I am happy to hear from you. Why don't you start by telling me where you are now, and if you're working now, what you're doing.
Yes, sir. So I am in Smyrna in my apartment here in Smyrna. I am working now. I've been with another restaurant. Monday will be a full year that I've now been with them.
Great.
Yeah, thank you. So yeah, and that certificate for best employee ever is being framed actually, so I couldn't show it to anyone.
Okay. All right. So talk to me about the situation with your previous employer.
Certainly. So as I shared in the previous hearing, the situation was I was hired at this restaurant after being with my previous place for 3 years. This was a brand new place. They were trying to get a Michelin star was what they were trying to do. It was a very high-end establishment. This was the type of place where the manager, I'm getting a lot of feedback. I'm sorry.
I can hear you fine, although, Deputy Gordon, would you mind cutting off Ms. Rivers's speaker? Your colleague put it on yesterday because we had a very soft spoke that when we were playing that video. I don't know if it's on the back. Is there a switch on the back? Yeah. You did it. Okay.
Okay.
Keep going, Mr. Levine. That hopefully will make it a little better.
Thank you. I appreciate that. So this was the type of place where the manager walked around with a ruler measuring the distance between the plate and the fork. I mean, it was
hoity-toity and excessive.
literally that type of restaurant. We were trained using the Forbes steps of service, which was a 70-step service system. Just to suffice to say, this wasn't a Chili's. This wasn't a place where you just slapped the menu down and said, I'll be right back with your.
Not that there's anything wrong with Chili's, but that wasn't the environment.
That is correct. So,
okay.
I was part of a bar staff that was employed 6 bar staff members. Each member of that bar staff was meant to work every night of the week that we were open, which was 5 nights a week. There was 4 bartenders and 2 barbacks. And I assume you're familiar with the restaurant business, or I don't have to explain a lot of these terms, or like.
Well, you should explain bar back, okay, because sure. I'm familiar as a customer of restaurants, more along the lines of Chili's than some Michelin starred restaurant. So I know what a bar is. I know what they serve at a bar.
Right.
But I don't know what a bar back is.
So a bar back is a support employee. Their responsibility is to assist the bartender in doing things like washing glassware, getting ice, replacing liquor bottles that have been emptied, like things of that, so the bartender can focus on servicing the guest. So that's what.
Were you a bar back or a tender?
No, I was a bartender, sir.
Okay.
There was 4 bartenders and 2 bar backs was part of the service team that was there.
All at the same time? Like there are 4 bartenders. How this bar is like 5 miles long?
No, so what I was about to explain to you. So there were 4 separate stations that the bartenders were responsible for.
Okay.
The bar consisted of 7 bar seats. 1 bartender was responsible for those 7 bar seats where guests could have a full service dinner. They were also responsible for serving guests, anybody that walked up to the bar, they could order drinks, that kind of thing. The end section of the bar was the service bar. That was responsible for making drinks for the guests in the restaurant. So any tables that ordered drinks, the servers would bring those in and the ticket would print up, and 1 bartender was responsible for that. There was 120 seats in the restaurant. So the night in question, we were fully committed, 120 guests. There was a lounge area. That lounge area consisted of 3 2-top cocktail tables, as well as 2 couches with 6 seats each, so 18 seats total in the lounge area. That lounge area up to that point was able to order drinks, they were able to order appetizers, and they were able to order desserts. So we had one bartender that was focused on that. That was their responsibility. And finally, the fourth bartender, we had a rolling martini cart, which was literally a portable bar that went from table to table, making drinks at the table for the guests. It was part of the elevated service. So one bartender was responsible for that. So as far as the two barbacks were concerned, one was responsible for keeping the main bar stocked. So anything that happened at the main bar. The second barback was responsible for the martini cart because that had ice and garnishes and glassware and all that kind of stuff. So that
was the martini cart literally just martini? Like if I wanted a scotch and soda, like, sorry, this is a martini cart. It's not a scotch and soda cart.
That is correct. So it did have a limited selection of what could be made from the cart. And anything else would have to be rung in and go through the main service bar.
Okay.
So that was the full bar staff, and that's exactly how it was designed to operate. On the night in question, there was only two of us. Four other members, two of the other bartenders and two of the barbacks were not present. They didn't show up for work or for whatever reason. That was beyond my control. So obviously we were trying to make do with what we could do as far as operate the main bar, operate the service bar, operate the martini cart, service the guests in the lounge area between myself and another bartender. Like I said, up to that point, we were only doing drinks and appetizers in the lounge area. But because we were so busy that night, the managers had made a decision to start serving full meals in that area. This was the point in contention, which led to all of this, which was I explained to the manager that we didn't have the capacity to do it. We were just, we were so overloaded with everything else that was going on. We couldn't do it. We were out of capacity. They replied that they would help. And I said, the help that we need is if you want to take tables, if you want to do this, that's the help that we need. Like it's just, it's not an ability issue. It's a manpower issue.
Right. It's capacity.
It's capacity. And I even suggested take some servers off the floor, give one server each, to each cocktail table. They've got a full complement of servers. Everybody was there. They have what they call back waiters, which are assistants for the servers. So they have plenty of staff to do that.
Yeah.
That was also not an acceptable solution to them. So, and this was in the middle of the dinner rush. So obviously it's very busy. It's a very high tension type time. Did I say it in a way that probably was the most diplomatic way to say it? Probably not. I mean, I didn't curse and I didn't yell, but I was, obviously I didn't use 10 words when 5 words will do.
Yep.
And that was the situation. And so we continued throughout the rest of the night. I continued to do my job for the rest of the night. We got through the night as best as we could. The end of the night, the manager had a conversation with me about just, my behavior that I shouldn't have told them to take the tables, regardless, my attitude, however they wanted to describe it. An interesting little side note to that, the managers did end up taking the tables and had to comp hundreds of dollars worth of food because even they couldn't do it.
Keep up, right?
Yeah, right. And that was it. And that was the long and short of it is, outside of that conversation, I had never been written up. I had never been disciplined in any way. I'd never been late. I'd never missed a shift. This wasn't a situation where I was a problem employee and this was the final straw. It was just a matter of there was a disagreement in the middle of this time about what could be done from a capacity standpoint. I guess they didn't feel that my answer was acceptable to what I thought could happen. I just kind of felt in that situation with the level of service that we were supposed to be providing, and what they were asking me to do, they tied my hands behind my back and they asked me to clap. And when I couldn't, they let me go.
Right.
So, that's really the bottom line, for the whole thing.
How long were you out of employment? How many months are we talking about? If we're able to rewind and say, all right, so you're terminated, you say without cause, so you're eligible. now I know you were working, good new job, been there for a year. So it sounds like you've been able to cover everything you're supposed to cover with your hands tied behind your back. So what was the window of unemployment?
So they originally said that they were going to do a 30-day review. That was their initial, they took me off the schedule while they were doing this 30-day review, so they wouldn't let me work. So that March, I believe it was March 14th was the day that I was taken off the schedule of 2024.
Yep.
On 30 days after that, I was informed via phone call from the HR department that they were terminating my employee, and I was no longer an employee of the hotel. So that was March 14th, 30 days, about April, about mid-April.
Yep.
From that time until July of that year, I was
Okay.
I was unemployed, looking for a new position.
Got it. So July was the happy time when you found this new job.
Yes, sir. It was very, very, very happy.
Good.
Yeah.
Excellent. Okay. This has nothing to do with any ruling I could make, but what's your theory behind, because of one microaggression on your part, talking to the manager in a way maybe the manager didn't want, on a busy night when clearly everyone was overtaxed because they're comping tables hundreds of dollars in food, to say now we're taking you off the schedule? Clearly they need people, they need good people, and things have been going well. It doesn't add up. Doesn't strike me as a rational business decision. Not that the restaurant business is rational, and when we're getting into the sphere of Michelin, it's more art than business, and I get all that, and that's why I tend not to eat there, plus all the zeros on the end of the bill. But it doesn't click. So as you reflect back on it, what would you say was behind it if it wasn't? Because of course there's the other side to the story where at your hearing they, there've been issues with Levine before, blah blah blah. But setting that aside, if one were to adopt your version of events, why do that?
So I'll say this. I was part of the original hiring team when the establishment opened. Out of, I think it was more than 60 some odd individuals hired for front of staff, only 3 remain in after a year. The GM was fired not shortly after I was. The food and beverage director, who was in charge of the entire property, was let go 8 months into it. This place was woefully mismanaged.
Okay.
It really was just a mismanagement situation. I mean, the sommelier left. We had a full-time sommelier. She is gone. I mean, there's really nobody left because they saw that this place was just not running the way.
It sounds pretty toxic. That's not the way to get your star. If you're running everyone off.
That's exactly correct. So they do have a whole new staff there basically because they had to replace just about everybody. Obviously I'm biased because I'm on my side, but I don't, this wasn't, the place was running like clockwork and John Levine just didn't fit into it.
Right. The one oddball. No,
Right.
It sounds like they were hemorrhaging good talent. Any of the castaways land with you wherever you are now?
No, but I still have kept up with some of them, and they have landed other places that they're much happier with and are still there a year later, which is good. So we all as a team, we were all very close and tight and worked very hard together. It was just overall from a program standpoint, it really just didn't work.
Yeah. Okay. Anything else you want to share with me?
I just jotted down some notes. I think I pretty much covered everything, which was everything that I had covered in the previous, hearing. So
sure.
But I think that's pretty much, the context of the whole situation.
How would you describe the role or the title of the person that the employer sent to your hearing? I've got the transcript, but I've learned that sometimes the way that gets conveyed is like, that's the head of HR. And the reality is like, nah, that was just like the chef or the whatever. Who was not the name, because I have that, but what was the role that the person had who was providing information for the administrative law judge on behalf of the employer?
So it was a member of the HR department. They were not the head of HR. They had said that they were, I believe, a week into the job because they had a bunch of people that they let go in the HR department or defections from, right. This whole thing was a I don't want to use the term, it's vulgar, but
Right, but I hear you.
an S show is what it was.
Yes, yeah.
So this person was a week into their job in the HR department who they had sent because I had asked questions about their knowledge of the situation, and they really said the only thing that they had to go on was the file. They were not there, and they were not even a member of the organization when this whole thing took place.
Okay, that's helpful. All right, Mr. Levine, I will take all this under advisement. I shared with you at the outset the ways in which my hands are tied in terms of appellate review, but I don't say that to give you no hope, just to manage your expectations.
Certainly.
But like we discussed, you did not present the Employee of the Year certificate because it's still being framed. You stuck with, look, here's what happened. Here's what I told the administrative law judge, and this doesn't seem to be a termination that was based for cause, or at least not consistent with policy, where there ought to be a series of interventions and graduated sanctions and everything. So I will look at what you shared and what the HR rep was able to share with the judge and take it from there.
Thank you very much, Your Honor.
You bet. Have a safe 4th of July.
You as well. Thank you.
All right. Bye-bye.
I don't know. It sounds like he's got a pretty good chance with Judge McBurney. I usually don't run Judge McBurney because his mic volume is very potent. We'll use that word. Yeah. Booming. And then everything else is, normal. So I typically don't mess with his court because then I have to edit every time he speaks. And adjusting the volume down is more frustrating than adjusting it up. It really is. But yeah, I bet we've all done the restaurant work. I know I have. And I think we've all worked in those kind of toxic environments. And so I figured that was one we could all relate to and perhaps jostle some fond memories out of us from our pasts.
Edna Squally, your name, please.
Gary Dickman.
Thank you, Ms. Diekman or Dykeman?
Dickman.
Dickman, okay. Ms. Dickman, you missed another pretrial this on the 9th of June after previously missing a pretrial back in January. So what's the problem getting you to come to court?
So
I can talk on Ms. Diekman's behalf, please.
Okay, go ahead.
One moment, Judge. Yes, Your Honor. Ms. Diekman told me that she was actually at a hospital at the end of, from December 28th to January 22nd. She actually also had a bench warrant issued in a parallel matter, Olympia municipal matter, for the same reason, for not being able to show up. She did quash that bench warrant once she was discharged from the hospital. Insofar as her picking up another bench warrant subsequently in our case, Ms. Diekman explained that she actually did not get the notification for the June 9th appearance until after the fact. She explained that she actually went over to the court and tried to quash it. She was told that it was a no-walk warrant, and she also left 2 voicemails with us trying to have the bench warrant quashed. For one reason or another.
It was a no-walk warrant, so she ran away.
We didn't do it, or we didn't get the voicemail in time, I'm not sure. But she did put the efforts into appearing in court and quashing her warrants.
All right, thank you. So actually, it wasn't a notice issue because Ms. Dickman was in court on the 8th of May with Ms. Capone and was provided notice in hand and left the court. I don't know if she left with the notice, but was given the notice on that day for the 9th of June. Ms. Dickman?
I got in the mail after that notices for the 21st of July and for a trial date. And I thought that those superseded. I called the courts and they told me that those superseded anything else I had.
So that sounds different than saying that you didn't get it in the mail.
No, I didn't get a different one in the mail that was for a different notice. I've got 2 court cases going on right now. And I was getting confused as to which was which.
And you received text reminders telling you, hey, you need to be in court on the 9th of June.
No, I've been being hacked. My phone has not been able to be consistent. And so I haven't had any text reminders. The phone, that number that the lawyer had for me was from 2.5 years ago.
1405?
What?
1405?
That's not my number anymore, no. I've been having to get a new phone every month. It's been hell. And I've been working with Officer Magdaleno of OPD about it.
What's the number now?
My current number is 481, but I often don't get incoming calls.
Slow down, 481.
But I often don't get incoming calls or texts. That's why I've been working with Officer Magdaleno, because I've been being hacked by somebody for 2.5 years and stalked and, you know. Officer Magdaleno of OPD.
And Mr. McClone, what's the city's request?
The city is asking the court to set some bail, given the history of the court is addressed. I think there's a third FCA in this case, and ultimately the court issued that no walk warrant as a result of prior non-appearances. The city had asked for bail back on that May 8th hearing, and she was released with date set. It looks like she called the court on the night, spoke to somebody. She mentioned that they advised of next dates. So I do think there's apparent issues more than what's being expressed. So I'm asking for $5,000 cash or bond, reset dates.
Thank you. Yeah, we will restart speedy trial today. Mr. Sabian.
Yes, Sharon, we're hoping the court will release Ms. Diekman on her own recognizance. She lives in the area. She gave me her new P.O. box that she still receives mail at. She also took out a new P.O. box that she also receives mail at. We'll put it in the chat. I have some concerns for her, but when I saw that she successfully quashed her warrant in Olympia, and then she made the effort to quash it here, she's trying to make her appearance as judge. And there's only one other case that's pending for her. I'm not seeing any other priors. I'm not seeing a big history of non-appearances over months and months and months or years. I think we need to have I think we need to give Ms. Diekman another chance here, and she'll be in good contact with us. She's also going through some things right now. She shared some of that, and she might need some treatment. She's okay with me sharing that, mental health treatment and such, and she won't be able to get that while she's inside.
All right, so it appears that she missed a hearing yesterday with City of Olympia. They've issued a new warrant.
Because she was in custody, Judge. Yeah.
Okay. All right. So, this is concerning. So she's in custody in the Squally, which is the City of Olympia holding facility. And they have a hearing for her yesterday and they don't get her on the calendar. Anybody have an explanation for that?
I was brought in that morning. It was a few hours before, and they said something about being behind, and I said, hey, I was supposed to have a hearing this morning. Can I talk to someone? And I never heard back about that.
You print docket on the Olympia case 962.
I was holding all morning. They
Okay.
didn't
All right.
have to pee.
All right. I won't count the Olympia warrant against you. That appears to be against Nisqually. Maybe I should hold them on some bail. But for you, with your history, I am going to impose some bail. It will be less than previously requested. It'll be $2,500 cash or bond.
I don't have any money at all. I get $450 a month, and I have no family to help me.
All right. And
part of that is because of all this stuff that's been going on with the hacking and everything.
I'll set a pretrial to 1:30 calendar on the 16th of July.
Which means I'll be in jail until then.
Yeah, unless you post the bail.
I don't have any way to post a bail. I don't have any money at all. I have. I don't even know
Thank
how to bail bondsman. I've never been in trouble before this last year.
Okay, but the main thing is you have to show up at court and you have to do everything in your world to make sure that that happens. And we're doing everything we can by sending text reminders, mailing notice, handing you notice when you're in court. You have to be up there. Okay. So this will be easy. You'll be in the jail and we'll see you 2 weeks from today. And that way we know you'll make the hearing. Thank you. Mr. Stashevsky.
Your Honor, present with me is Mr. Markel Morgan Johnson.
Ooh, we're not going to watch Mr. Johnson's case. I just left that up there so that y'all could see that evil look she gave to the judge before getting up out of that chair. And those tears dried up so fast. They really did.
At Nisqually, your name, please.
Hello, Judge. My name is Tyson Miller Willis.
Thank you, Mr. Miller Willis. And Mr. Miller Willis, you had a chance to go over your constitutional rights with Mr. Sabian.
Yes, sir.
Any questions for me about those rights?
No, sir.
Okay, and how about a cell phone number?
425.
Thank you.
Yes, sir.
And you went over your constitutional rights with Mr. Sabian?
Yes, sir.
Have any questions for me about those rights?
No, sir.
Mr. Sabian, any objection to probable cause today?
Oh, one moment, Judge, please. Thank you. No objection to finding a probable cause at this time.
Well, no probable cause on charges of vehicle prowl and possession of vehicle theft tools. Enter not guilty pleas for Mr. Miller Willis to those charges. And Mr. Sabian, appointed counsel or hiring counsel?
Can I ask you a question?
To Mr. Sabian for today, yeah.
Okay, Mr. Sabian, it says, I didn't know anything about it said vehicle theft tools. I just had a couple of wrenches in my pocket.
Okay, yeah, hold on.
Never
Hold on.
stole any cars.
Yes, Judge. Mr. Willis is seeking appointment. He does work at a warehouse. He does help out his girlfriend with the bills. They live together. I neglected to ask him his income level, though.
Also, my dog was taken to the pound. I've had him since he was 6 weeks old, and he's 5. I really got to get him out of the pound.
All right, so tell me what your average monthly income is from work.
Maybe like 1,300 to 1,500.
Okay, thank you. I will appoint counsel to represent you. That will be Pacific Point Defense. I will order that you pay $50 to help defray taxpayer expense of providing service of counsel.
Yes, sir.
And Mr. McClellan, city's position on release. And are you making motions to revoke on the backup matters?
Yes, CD is making a motion to revoke both on the cause number ending in 0327 and 8810 is on probation, both for a theft conviction and unlawful use of drug paraphernalia. This case now alleging looking vehicles and having taken items from a vehicle. The city has concerns in violating the terms of a sentence and by these new law violations. The city also notes warrant history from the last couple of years. So that's for $2,000 cash or bond on each case. No contact or no criminal law violations, no contact with the Gateway Apartments, which is where the alleged vehicle prowling was taking place.
All right, thank you. Mr. Sabian.
Yes, Your Honor, we're hoping the court will consider releasing Mr. Miller Willis on own recognizance. He is staying in the county. He's not leaving. He is currently employed, helps out his girlfriend with the bills. He asked all the right questions about the allegations in this case. For what it's worth, he's interested in seeing what happens next, if you will, but I don't see him absconding or failing to appear in court. Whether he's ultimately found guilty of this is a different matter, but I think is a good candidate for being released. He might have difficulty posting any bail bond because of his income was pretty much goes towards his living expenses and his girlfriend's expenses. Thank you, Judge.
All right, thank you. And, okay, hold on.
Yes, sir.
And Mr. Fortunato, what's the state can be recommending on its, I mean, I assume you're making a motion to revoke?
We are as well, Your Honor. I would, join in the city's request. If posted, I will note that there is currently a hearing set for next Thursday, or at least a review for next Thursday. He was to have turned in 8 hours of community service based on the 2 prior Lacey convictions. I don't know if that has been completed, but I don't see it in the court file.
All right, so your motion to revoke is based on the new law violations as well as
I
failure to
did
provide
complete it.
proof of community service.
That's correct.
Okay.
I did complete the community service.
Did you get the documents to us?
Pardon me?
Did you get the documents to us to prove that?
I sent them in the mail to the courthouse.
When?
I think it was like the 14th or something of last month. I volunteered at the animal shelter.
We have a review hearing scheduled for the 2nd. We can just keep that. Or, no, we don't have a review hearing
Today's the
scheduled for the 10th.
I think that the due date was the 10th. I was going to say, Your Honor, I have not had the chance to speak to Mr. Miller Willis, but I would ask that the court not impose any bail on, or does not, not hold him on this probation matter and allow him to address these matters out of custody.
Are you his counsel?
No, there is this Tumwater backup, Your Honor.
No, I know that, but I mean, I'm wondering if the community, he said he sent it into the court. We don't have any record of it.
I can look in our file, Your Honor.
Yeah, that's what I'm asking.
I would be surprised if it was in our file, but it sounds like it may have been sent to the court and just not gotten here and processed. I don't have anything in my file.
All right, so Mr. Miller Willis, we don't have anything either regarding community service, so I'm just letting you know that.
Yeah, I don't know what to say.
I would just highlight for the record that it will be more difficult for him to show proof of that community service that he's completed if he is sitting in jail, Your Honor.
All right. And I will appoint counsel as well to represent Mr. Miller Willis on the state's motion to revoke the suspended time on the reckless driving charge. Set that matter for a preliminary failure to comply hearing.
That'd be on a Thursday calendar, Your Honor, or on Monday.
I'm sorry.
Will that be on a Thursday calendar, Your Honor, or on a
Yes,
Monday?
on a Thursday.
Thursday.
Thursday, the 24th. Also at 9 o'clock. All right, Mr. Miller Willis, here's what I've done. You'll be held on $1,000 cash or bond on the new Lacey case, $500 cash or bond on the other 3 cases, total $2,500 cash or bond. Your next court date is the 21st of July for the Lacey cases and the 24th of July for the state case. We'll see you then. Thank you.
Sir, my dog. I'm gonna lose my dog.
All right.
How about you not take your dog when you're going to go peeking in cars and stealing items from them? Because, you might get arrested for it. And then your dog goes to the pound. Your dog isn't a wingman or, a cover story for being able to commit your crimes. It's your best friend. And you should just be walking it, not using it as a way to make it look like you're walking your dog. Really, you're breaking into people's cars and being a dirty, rotten little thief. I hope the dog gets a better owner.
And the squally, your name, please.
What's that?
Your name, please.
Oh, Nathan Ritter.
Thank you, Mr. Ritter.
There's a resolution anticipated for the pending case, and then
Thank
resolve
you.
the backup
I do
matters.
have a plea form. When I open up this form, is it going to be signed?
Yes, I'm hoping the court can approve Mr. Ritter's signature on the court's end.
I'm curious to see if we have any. Let me look.
No, you won't find it, Your Honor. And I'm trying to work on that.
That invisible ink.
Yeah.
All right. Mr. Ritter, good afternoon.
Good afternoon.
Mr. Ritter, I have in front of me a statement of defendant on plea of guilty to the charge of theft. And as you heard me discuss, there are no signatures on the plea form, but I'm assuming you agree you did discuss a guilty plea with Mr. Sabian, is that correct?
Yeah.
And you went over a form that I'm going to go over with the assumption that it's the same one you reviewed with Mr. Sabian. So as I go through it, pay attention and make sure you let me know if it's a different form, okay?
Okay.
All right. By pleading guilty to that charge, you give up the constitutional rights set forth in paragraph 5 of the plea form. You understand that?
Yes.
That's the right to go to trial, the right to call witnesses, the right to cross-examine witnesses, the right to testify, the right to appeal. You're giving up all those rights. You understand that?
Well, is the plea deal for me to have electronic custody so I can keep my job?
It's going to be open sentencing, Mr. Ritter. Sorry, Judge.
Haven't gotten there. So it sounds like there's no deal there. I haven't made any determination.
Oh.
So we'll see. But that could happen.
Okay.
So you understand that?
Yeah. Yes, Your Honor.
And do you wish to go forward with the plea?
Yes, Your Honor.
Okay. And Mr. Sabian, you discussing potential immigration consequences.
Yes, Your Honor, I have.
Okay. And Mr. Ritter, you understand the sentence recommendation appears to be 20 days in custody.
I'll lose my job if I do that.
Okay, right. We're not talking about that. I just want to make sure you understand what the city is recommending, and I'm trying to figure it out here. So sit tight.
Yes, sir. Yes, Your Honor.
If you'll mute them, that's at the arc. Thank you. Okay, you were picking up voices from the other jail, Mr. Ritter.
Okay.
All right. Let's see. Looks like. Here's how I read this. The city is recommending 20 days of jail. Mr. Sabian is going to argue for 30 days on electronic home monitoring on this case. And then the city also is asking for an additional 10 days in jail on the backup matter, which is case ending in 365, which would be the case.
I thought we were asking for home monitoring because if I miss another day of work, I'm going to lose my job. I've been working there for 5 years.
So that's another theft case that is, wait.
That's correct, Your Honor.
Okay, so the city is recommending 30 days on the other theft. Pardon me, 30 days, let me start again. 20 days in jail on the new theft case, or 30 days in electronic home monitoring, and it'll be up to me to decide. And then on the prior theft case, an additional 10 days in custody. And that accurately states the city's recommendation, Mr. McClellan.
So this, yeah, I think so, but I'll clarify. The city's asking for 20 days on the pending theft case that he's pleading guilty to. We would then be recommending a 10-day sanction consecutive on the backup case. The city is asking that all be served in custody. Defense is going to be asking the court to allow for options, including electric home monitoring on any time imposed, potentially days total.
And did I hear something earlier about the forfeiture of a weapon?
What?
Okay, so it was EHM that we were talking about, not some, okay. All right, and you would be told to have no contact with the Ultra Beauty store for the next 2 years and no criminal law violations. You understand all of that?
Yeah, is there any way we can do the ankle monitoring so I can keep my job?
I haven't decided that yet.
Oh, okay.
I'm just letting you know what the city's recommending. That's it.
Here's another one. You want to keep your job, go to your job instead of going to the Ulta beauty store and stealing. You know, I mean, it's so simple.
Okay.
Okay. You have any questions about what the city is recommending?
No, Your Honor.
Okay. Your statement indicates that on the 16th of December of the year 2022 in the city of Lacey, you took property from Ultra Beauty. It doesn't say that, it says from somebody else, but I'm guessing it's Ultra Beauty. And you left without paying for it, and it was in an amount less than $750. Are those facts accurate?
Yes, Your Honor.
Okay. Does this sound like the plea form that you discussed with Mr. Sabian?
Yes.
Mr. Sabian, does this sound like the plea form you discussed with Mr. Ritter?
That is correct, Judge, yes.
Mr. McClellan, is the city endorsing this plea form?
Yes, Your Honor.
Thank you. I'll find the pleas made knowingly, voluntarily, with full understanding of the consequence. Accordingly, I will accept defendant's plea, enter finding of guilty based on that plea.
And then, when appropriate, the city would like to briefly be heard for sentencing.
Yes.
Can I speak, Your Honor?
Not yet. I'll let you know. You are going to have a shot.
Okay.
So, Mr. McClellan, the plea form says Ulta Beauty. Is it Ultra Beauty by chance?
I think it is
It should be
Ulta.
Ulta, Judge, without the Ultra.
Ulta Beauty.
Okay. Huh. Interesting. All right. Counsel, on the case ending in 3618, the case that the plea is on today, pardon me, the case ending in 365. All right, so what I'm looking at is trying to see credit for time served. I see Mr. Ritter came into custody yesterday on this case, but I look back to 2022 and the date of the offense is 16 December, and I see Mr. Ritter having posted bail with the court on the 12th of January. You know, I understand that Nisqually frequently is late getting the bail money to the court, so I have no idea when that was posted to get Mr. Ritter out of jail, but it looks to me like he was in custody at some point. And I'm going to ask counsel to give me their best information if you have any.
Yeah, the note I have at arraignment on the 19th of December, he was at the jail. He booked in obviously on this incident from the 16th. At the arraignment, our notice noted that he did post bail. So whether he was released, and it didn't get approved, but it looked like he might have been released.
Yeah, I don't have any information as to release time. Whether it was the night he got arrested or on the 19th. Actually, I have that information. It's in the file.
I think,
maybe not.
I think he was, I'm looking at one of you even appeared out of custody. Because on the 19th, that note in the docket says posted bail to remain. I think the court kept that bail and then he was out of custody.
All right, looks, I see a document that, from Seaview Insurance Company who bailed him, dated December 18th. So I'm going to use that as the date that the bail was posted. So I'll give him 2 additional days of credit, which would be a total of 4. Okay. Mr. McClellan, you wish to make your point?
Yes, Your Honor. I'll just note on that case where he pled guilty to ending in 3618, the backup case, he pled guilty to that on November 8th, 2022, and the court sentenced him to 10 days and authorized options. And noting, looking back at the docket text there, he didn't serve that time initially until then he was had the new law violation. The court, I believe, reimposed those 10 days, gave him, still allowed for options. And whether you serve that time, really looking at the docket text now, I don't know if that's actually been resolved, but partly the objection to EHM is that the court authorized that and he didn't follow through timely, if at all. And then this case, it is a misdemeanor, any plat or a gross misdemeanor. The officer in the report, it was over $750 that was alleged initially, but the county wouldn't book on that, and so they booked him into Nisqually. We charged it or kept it as a gross misdemeanor. On the positive, I don't think since this there's been other similar charges against him, but he did have a prior felony theft and burglary, and then this, as I mentioned, alleged a significant dollar amount, and then we've had the FTA history in addition to that, and so I understand he's and anticipate him expressing concerns. The city is not intending to interfere with any job opportunities, but at this point, I think 20 days is fair and appropriate. And then additionally to that, a sanction for committing this offense while on probation. So the total of 30 days is the city's request, and we're asking that to be served in custody.
Thank you.
It's not a job opportunity, it's my livelihood.
Okay.
I speak, Your Honor.
Yeah, hold on.
Yeah.
All right, okay, there was a long period of absence here. I'm looking specifically at case ending in 3618, 2 years jurisdiction originally taken at the time of sentencing, which was November of 2022. In June of 2023, the court issued a warrant for Mr. Ritter's non-appearance in court, and that warrant was just served yesterday. So the 2 years jurisdiction still, see, with 7 months having been used prior to the warrant being issued, that leaves 17 months of jurisdiction on that case, and I'll give us a date for that. So that 17 months will take us to December of 2026. Today being the 2nd, I'll make it the 2nd of December. So on the case ending in 3618, that jurisdiction runs through December 2nd of 2026. Mr. Sabian, any objection to that calculation?
No, I don't.
Okay, Mr. McClellan, any objection?
No, you're not to that calculation.
Okay. All right. Mr. Sabian, on the state or city's request for in custody time versus other time.
Yes, Sean, I think we can all appreciate how important having a job is, especially now that the country lost 33,000 jobs in June, for what it's worth. Mr. Ritter just made foreman recently. Works for Makey Lumber in Tacoma. He's been doing it for about 4 or 5 years. He just gotten a substantial pay bump. He's super happy about that. He's able to take care of his dad and the nephews, and he lives with them. They pretty much rely on him. He's been working on getting his driver license reinstated, and he informed me that there was a hold out of Oregon. He's not sure why. He's trying to resolve that as well. I think we should all save everybody the resources and the time by keeping him in jail, but instead allowing him to do electronic home monitoring, which he can't afford now. He might not have been able to do it in 22, but he can do it now. And he really wanted to stress the importance of this job, and missing even one day, which he so far has missed, would have devastated impact on him. Also kind of went through his history. Looks like the only things that he picked up recently were the driving while license suspended and no more theft, judge. So it looks like he, at least as to those types of offenses, perhaps he's turned his life around. And now that he has the resources and the time now that he has the resources and the means to support himself and the other family members, he's staying out of trouble, at least in that regard. So, but
he doesn't have the resources and means not to steal. Oh, wait, it was from Ulta Beauty. So he only steals, non-essential goods. I get it.
He wanted to really, really stress to the court how important this job is to him and to his family members. And there's no issue. I don't see any issue with him being able to finish electronic home monitoring with 30 days, and he has the means to pay for that. Thank you, Judge.
All right, thank you, Candace. Will you send me back the GNS on 365? And Mr. Ritter, anything else you would like to say?
I'd like, if we could do the electronic home monitoring so I can pay my debt to society and keep my job at the same time, that'd be great. I'd appreciate it.
All right, thank you.
Your Honor, could I add one thing?
Go ahead, Mr. McClellan.
Just my understanding as well is that Nisqually does have a work release program. I can't say that I've spoken to them to see how it's played out in every case, but when I have checked with them, I'm routinely told that they have that option. I'd ask the court if the court is considering options to perhaps include that in the thought. Thank you.
And if I may, Your Honor, we actually did discuss work release. I wasn't aware that Nisqually did those. I don't think Thurston does anymore, but actually, Mr. Ritter is the one that actually brought that up when we spoke originally, if that's where the court is leaning.
All right, thank you. All right, Mr. Ritter, here's what I'm going to do. On the new case, I will impose 30 days in custody. I'll let you serve those 30 days on electronic home monitoring. I'll give you credit for 4 days you've served. That leaves 26 left to serve. On those 26 days of electronic home monitoring, you have to be on the home monitoring before you come out of jail. So you're going to have to set it up. I'm not going to release you to go get it set up. I don't trust you because we are going to deal with that problem on the other case. You had months to do your 10 days EHM last time and it never happened. So you're going to have to set up the electronic home monitoring from the jail. So you'll want to get started on making calls to have that all set up. And that'll leave 334 days suspended for the next 2 years. And during that 2-year period, you're to have no contact with Ulta Beauty and no criminal law violations. And on the backup matter, you owe the court 10 days of electronic home monitoring. As I pointed out, you never served it. And the price of that is you're going to serve it sitting in the jail. I'll give you credit for 2 days on that case. That leaves 8 days left to serve. And when you'll be in jail for roughly the next week. And then that case, the jurisdiction runs, as I said, until December 2nd of 2026. Okay, there you go. So you're going to serve 7 days in jail or 8 days in jail, and then you'll get out to serve 30 days electronic home monitoring. But you have to have that set up before you leave. So otherwise you'll just stay in the jail for all 30. So you're going to want to get busy and getting those set up so you can get back to work. Okay, thank you.
The judge basically maxed him on the jurisdiction for the probation aspect. He's got 364 days hanging over his head for 2 years of probation. So if he violates, he's sitting that full year. Wow. I do love this judge. I really do. He's, in my opinion, he is one of the toughest Washington judges that there is. Like I said in the chat, what he can sentence people to, that the laws set that. His hands are tied. But how he can put those numbers together and how he can stand on not taking pity parties and not being swayed by crying or any of that, he does it.
Your Honor.
Yep.
Your Honor, I'm here with Mr. McMillan, matter 31 on the calendar. I believe it's my understanding that his representation is Mr. Martinez, who I'm not seeing on Zoom at the moment.
I know he's booked on a new felony. I think maybe that might be the attorney. Mr. Sabian, I think, met with him on the Lacey case.
Yes, that's Mr. Martinez is for the Superior Court appearance, which I don't think Mr. McMillan has had yet.
Okay, and what are we doing today on the Lacey case?
We're hoping to resolve with a plead guilty as charged and credit for time served. Yes.
Okay, and Mr. McMillan, we're not going to get anywhere if you're just laying on the table there. If you want to take care of it, you're going to have to sit up and respond. Did you have any competency concerns, Mr. Sabian?
Sleepy mood, Judge. Didn't quite see anything other than that.
Okay.
Didn't notice anything.
All right, Mr. McMillan, do you want to do this today or do you want to do it on another day when you're more rested?
Yeah.
Was that today or tomorrow?
Today.
Okay, so I need your full attention. I need you looking at the screen, talking to us. Otherwise, we can't do it. We'll have to put it off till tomorrow. All right, Mr. McMillan, I have in front of me a statement of defendant on plea of guilty to a charge of driving suspended third degree. Once again, I don't have any signatures on there. Did you discuss a plea form with Mr. Sabian, your attorney, today?
Mm-hmm.
Okay, you're going to need to answer in yes or no's.
Sorry, say it one more time.
Yes.
Okay. And do you have any questions for me about the form that you discussed with Mr. Sabian?
No.
Okay. And since I don't have signatures on here, I'm going to run through the form and ask that you listen carefully so you can let me know at the end whether this is the same form you discussed with Mr. Sabian.
Okay.
You understand, by pleading guilty to the charge of driving suspended third degree, you give up the constitutional rights set forth in paragraph 5 of the plea form.
Yes.
Thank you. And you understand the sentence recommendation is to all the jail time suspended for 1 year. You'd be released from custody today. You understand that?
Yes.
And your statement here indicates that on the 21st of December in the city of Lacey, you were driving a motor vehicle, and on that date, your privilege to drive was suspended. Are those facts accurate?
Yes.
I'll find sufficient factual basis for defendant's plea. Mr. Sabian, is this the plea form you discussed with Mr. McMillan?
It is, Judge.
Mr. McMillan, is this the plea form you discussed with Mr. Sabian?
Yes.
And Mr. McClellan, is the city endorsing this plea?
Yes, Your Honor.
Thank you. Find the plea is made knowingly, voluntarily, with full understanding of the consequence. Accordingly, I will accept defendant's plea, enter a finding of guilty based on that plea. Mr. Sabian, anything further on sentencing?
No, Judge. Thank you. We're asking not to impose any fines. That's all.
Thank you. And Mr. McMillan, anything else you want to say?
No.
Okay. 90 days in jail. And let me see here.
I don't believe he has any credit on.
He has
Well,
2
he
days
has
from the original warrant in January. Okay, so 2 days in jail, credit for 2 days served, 88 days remain suspended for the next year. On condition that you don't drive unless you have a valid license and insurance and have no criminal law violations, I will order your release today. I will not impose any financial costs.
Don't drive unless you can stay awake. Unlike now.
All right, thanks, Mr. McMillan. You're all done. And as a would, yeah, that's it. Okay, thank you.
That guy was just, oh, he popped one too many Xanax before he got picked up. Seriously, he was out of it. At one point, the corrections officer had to come in and shake him awake. Yeah, you cannot convince me that was normal. Oh my gosh. Earl, would you let Bandit get a drink, please? Earl is sitting on the floor and will not allow Bandit to get to the water fountain. That when I announced that the cat case was starting, that these two came tearing into the room, Earl chasing Bandit into a corner. Ugh. Oh, well, no. I mean, I wouldn't think you would want to, especially, after they do procedures on your eyes like that. It's a little dangerous, bro, getting in the car after that. Oh, Earl's after a mosquito now. Oh my gosh. They're going to destroy my house. It's over, guys. Aww. All right, guys. I'm going to have to deal with a little situation here. So, I'm going to let y'all go. Because yeah, here, Ava, you can lick the kitty lid. I was using it to scoop food out of the dish earlier and let Bandit eat off of it while Tiny Kitten Esquire was eating out of the bowl. It's been a fun one with the kitties on this side. Oh, you quit talking mean. No wonder Earl chases you. You're such a meanie. Earl, you put those ears back. Bandit, you put that grumble away. Thank you guys for coming out. I appreciate every one of you. And I love you all. Be safe, be well, sleep sweet, and much love.